Hello, I'm Grant Barclay and I convene the Legal Questions Committee. I'd like to take you through its report in all its 12 sections. The first section is really not our business, but that of the Assembly Business Committee, and you should look there to find out more of the detail. The second section offers an update on work on a new Church Courts Act, which will be a significant attempt to update and clarify the law around kirk sessions and presbyteries and the General Assembly. We hope to bring legislation to next year's Assembly. One of the more significant pieces of work is contained in the third section. This year, we offer draft legislation for the solemnisation of same-sex marriage, together with the assessment that the safeguards inherent in this approach do sufficiently protect against the risks which they identify. This is to fulfil the instruction of the work given to the committee in 2018. The Procurator's supplementary opinion is included in Appendix B. It explains some of the legal background to the approach which the committee has taken and the attempts made to secure compliance with the applicable provisions of the Equality Act. The Draft Act, which is in Appendix A, makes clear that no person shall be required to participate in the solemnisation of or be involved in the arrangements for a same-sex marriage. Those who wish to celebrate same-sex marriages will be able to register through the Principal Clerk's Office under Section 9 of the Marriage Scotland Act. The Act restricts the church buildings which may be used to those which someone authorised to celebrate same-sex marriage is entitled to use. Now, this protects those who do not want to authorise the use of premises over which they have control for the purposes of same-sex marriage. This is a protection which is supported by law. At the same time, the rules on intrusion are relaxed to the extent that someone authorised to celebrate a same-sex marriage may enter another parish to conduct a same-sex marriage where the parish minister is not so authorised. The church building of the non-authorised minister may, though, not be used for the ceremony. Provisions also cover those whose contributions are required to enable the marriage service to proceed, such as church officers, organists, and others. The general principle is that no one who does not wish to be involved in the celebration of same-sex marriage shall be required to do so. And at the same time, there must be permission to others to undertake the required duties. The principle of protection and permission runs throughout the Act and the committee's thinking. The committee has discharged its responsibility by making this material available. The committee is, however, not arguing for it. All the documentation required to send this matter down under the Barrier Act is included in the report, but there is no deliverance in the committee's name. It is for the Assembly to decide what, if anything, is done with this material. The Legal Questions Committee offers no theological reflection on the matter. I do, though, point out that the consequential amendment articulates a change in the Church's understanding of marriage to the extent that it amends the Recognition of Marriage Services Act by removing the words as husband and wife and replacing these with in marriage. It shall be for the Assembly to determine what steps, if any, are now taken. While the committee is charged with developing a system of peer-led review of presbyteries, Section 4 suggests that this should not reflect the current arrangement of presbyteries, for we anticipate substantial change over the coming few years, and instead, further work will be carried out in coming months. The question of legal costs for those subject to disciplinary proceedings, has been explored and is described in Section 5. It has proved impossible to secure insurance to cover these expenses. The committee's view is that the current processes for assessing cases provide adequate protection. Additionally, union membership may be another route by which ministers could secure funding for legal representation. Notwithstanding this, the committee undertakes to conduct a review of the legal aid in disciplinary proceedings regulations in the coming year, with a further report to next year's Assembly. We explored the possibility of using alternative dispute resolution procedures in presbytery planning cases and conclude that this is not appropriate where a final decision needs to be reached, as opposed to some position being negotiated. The recommendation is that a prompt review of such cases by an experienced group may prove more useful. We note that such a process is included in the proposed Presbytery Mission Plan Act, which comes to the Assembly under the port of the Faith Nurture Forum. At the same time, we offer an alternative route if that Act is not passed. This important piece of work has revealed the need for some assessment of cases being brought, and the committee also seeks authority to review appeal processes to consider strengthening the review issues of competence and relevance at appeal management hearings. In Section 7, the committee reports on a departure from updating Weatherhead's work on the Constitution and laws of the Church of Scotland, preferring instead an online resource which is capable of being updated more regularly. We intend to learn from other denominations and their approach as we develop this work. And speaking of technology, the committee recognises how indispensable internet-based communication has been to ongoing decision-making of the Church, certainly over this past pandemic year. The present permissions to meet remotely are therefore extended, given the evident benefit which they have provided. Of course, stated annual meetings have not been held. Some elements of these meetings may be addressed by providing accounts and reports to members of congregations. However, the appointment of congregational board members is not likely to be possible by June of this year. Some alternative approaches are being outlined in Section 9, and authority is sought to pass a further protocol should this be considered necessary. The final three matters in Sections 10, 11 and 12 cover a small amendment to timescales in the operation of the Discipline Act. The detailed information is contained in Appendix C. They point to a revised remit for the Legal Questions Committee, which will be brought to the Assembly by the Assembly trustees, and also remind the Assembly that while it has not been practicable to inspect the records of forums and councils and committees in this year, the task of inspecting 2 years' worth of records will be a double joy for those willing members of the committee at some point in the future. I conclude by noting that in a year in which the Church's usual legal processes, from Kirk Sessions to the Assembly itself, were challenged almost as never before, it was nevertheless possible to adapt our practices while retaining our principles. We were able to continue to follow Christ's call in our decision-making as well in our serving and our worshipping, for all that these may have looked quite different from what we were used to. I want to pay tribute to the creativity and hard work of the Office of Principal Clerk, and particularly to George White and Christine Patterson for their dedicated effort over a prolonged period to ensure the Church's legal framework is put to good use in the service of Christ's Church. Normally, I'd present the report at this point. However, since you're watching this online, I'll stop now, and I look forward to seeing you, albeit at a bit of a distance, at the General Assembly in May.